All right, pursuant to
like it.
Section 84-1411 of the Nebraska statutes, notice of this meeting was given on Thursday, October 7th, 2021. Pursuant to Section 84-1411 of the Nebraska statutes, the next regular meeting of the Board of Trustees will be held Thursday, December 2nd, 2021 at 4 p.m. in the Board Conference Room, second floor at the Teacher Administrative Center, 3215 Cumming Street here in Omaha. The agenda will be kept current and available for public inspection in the retirement office at the Teacher Administrative Center during regular working hours. Pursuant to Section 84-1412 of the Nebraska statutes, the public is hereby informed that a current copy of the Nebraska Open Meetings Act is posted in the Board of Education meeting room on the north wall. With that, Cecilia, would you call the roll?
Bourne.
Here.
Erdenberger.
Here.
Block. Head.
Present.
Hersenbach.
Here.
Johnson.
Here.
Logan.
Present.
6 present.
All right, thank you, Cecilia. So with that, 4 times a year, the OSERS meeting is open for public comment, and this is one of those meetings. So we currently have one speaker who has submitted the form to speak in alignment with the OPS Board of Education, which provides public comment for a period of 1 hour, and the same policy limits individuals to a maximum of 5 minutes. We ask that you respect that time limit. Ms. Carter will let you know when you have 1 minute remaining and when you have 30 seconds remaining. If you are in need of an interpreter, please let Ms. Carter know, and one will be provided for you. If the subject of your public comment is related to a particular staff member or transition trustee board member, we ask that you not mention the staff member or transition trustee board member by name, and instead provide that information to Ms. Carter. She will assist the board and look into those details for you. If you do not get an opportunity to speak and would like to submit written commentary, please provide it to Ms. Carter. She will make sure that each member of the board gets a copy. And as a reminder, we ask that you please spell your name and state your street address before you begin your public comment. It's now time, 4:03. We will begin the 1 hour count. And the first speaker is Walter Sue Dodd. Welcome.
Decisions being made, but not all OSERS members belong to the various retirement organizations and have access to websites or have computers. There needs to be better communication to all 5,000 members as the process proceeds and the various changes being made to the plan. The notice that their check notification could be late was not sent to the members. In January, notice should be sent informing members about the cost of living change for 2022. We understand the Board of Trustees make recommendations to the school board, which makes the final decision on any changes. We would like all members to be kept abreast of those recommendations. Thank you for your time.
Thank you. All right. Is there any further public comments? Thank you. With that, we'll move on to agenda item number 3. Cecilia sent out the October 7th meeting minutes in the board packet. I'd look for a motion to approve those minutes.
So moved.
Second.
We have a motion and a second. Is there any discussion regarding those minutes? All right. Seeing none. Cecilia?
Head.
Aye.
Logan.
Aye.
Erdenberger.
Aye.
Block.
Aye.
Johnson.
Aye.
Hersenbach.
Aye.
And Bourne.
Aye.
7 ayes.
All right. They are approved. Next agenda item is a discussion of the presentation by Ice Miller on the Osiris-Compliant audit. Pursuant to LB 147, if you recall that some time ago we entered into an agreement with Ice Miller to perform that. Today, Rob Goss, Esquire, and Audra Ferguson Allen, Esquire, Vice Miller, are here to present their findings and recommendations on the OSERS-Compliant audit. So with that, however, the floor is yours, however you want to use it. Welcome.
Thank you. Thank you, and thank you to members of the board. It's nice to see you in person as opposed to over a video screen. My law partner, Audra Ferguson Allen, and I are going to break up this presentation. You were given very substantial materials. We are not going to go through those line item by line item. We recognize that you have other things to do this evening. But there was a method to the madness, and I want to talk through that just a little bit. If I do this. All right. Does this help?
Yeah.
Okay. Under LB 147, we recognize that as of July 1, 2021, the Board of Trustees and the Administrator of OSERS are required to administer the plan in compliance with the qualification requirements applicable to a governmental retirement plan. This means in accordance with Internal Revenue Code sections 401A and 414D. The board members are also deemed to be fiduciaries with respect to the administration of the plan and have the obligation to act with the care, skill, prudence, and diligence then prevailing that a prudent person acting in a like capacity would use. LB 147 also requires a compliance audit to include an examination of records, files, documents, and resources to determine compliance with state and federal law. And we want to make sure that you know that staff and counsel have been completely responsive to our requests for information and records as we perform these different parts of our compliance audit. We've separated the compliance audit into two parts intentionally. One is a review of the plan as written, and the other is an operational compliance review. I'm going to address the part of the audit that is the written plan, and Audra will talk about the audit of the plan in operation. For purposes of our audit of the plan's terms, we performed a review of the plan as if it was being submitted to the IRS for a determination letter filing. I think we've talked about in the past. That was a program that was voluntary where a plan could be submitted to the IRS for review. Those happened on 5-year cycles, and many governmental plans took advantage of that program. In 2016, the IRS suspended that program. But if you did not already have a determination letter, you're eligible still to file the plan for review by the IRS. And that's what we did. That's what we're reflecting in our audit report that is of the plan as written. In general, our finding is that the plan was in pretty good shape, but we did note some amendments which we recommend to be made and identified those in our suggestions to the board rules and regulations, which we provided on August 9, 2021. Also, as we were finishing our review, we identified one extra amendment that we would recommend that deals with rollovers from the plan. We submitted that as an attachment to our review, and we believe that those suggested amendments to the board rules and regulations, as well as this one suggested amendment on rollovers, would put the plan in a written form to easily be submitted to the IRS. There were a couple of plan amendments or plan provisions which were adopted, but were adopted late based upon different requirements under federal law. We identified those for you. If the plan were to be submitted to the IRS, we would recommend that it also be submitted for what's called a voluntary correction. That's a program by which a qualified plan confesses its sins or mistakes to the IRS. They call them failures. It has different levels. But in the situation where you've got a late amendment, you basically just notify the IRS that there were certain amendments that were adopted late and what you've done to correct that error. As we noted in our cover letter, the IRS has two fees. If you're filing for a determination letter, the filing fee or user fee is $2,700, and the filing fee for a correction is $3,500. Those are just fees to the IRS. There certainly would also be legal fees incurred in preparing both, but with the report that you have, most of the work to prepare for determination letter filing has already been done. There are still some forms that go along with that and some demographic data that's provided to the IRS, and that could be done relatively easily. So other than the amendments that we've suggested, most of those corrections were to be specific to this plan. We know that in the rules and regulations, there were some rules brought over from the state plan, so there were references that were not correct that had caught our attention. There was also just some recommended amendments that we thought would put the plan term or the rule in a better position if it were to be filed, and so those were the recommendations we made. And at that point, let me stop and ask if there are any questions about that part of our report.
So real quick, you said, I'm sorry, go ahead, Jane. You had said most of the work to file is already done. So is that Ice Miller work, or is that OSERS staff work that remains to be done in order to file for those?
No, so what I mean by that is with this report that we have provided, including all of the legislative history related to when deadlines of different provisions are required, most of that work has already been done. We've also included a compliance checklist that would be used as an exhibit to the determination letter filing.
Got it. Thank you.
You're welcome.
Jane.
I just want to make sure I understand what the rules and regulations are that you're referring to. I was on the policy committee for the school board, and we spent a good part of the summer adopting the rules and regs for this OSERS. And I'm a little confused on the timing. Did you say that there are some revisions that you submitted in August that we should still put into those rules and regs? Is that what you're suggesting?
We had provided comment to those, Cecilia.
And I don't know.
Yeah, correct. So we received those in August and went through them, but we also have some staff recommendations. So we're going to come back to the OPS policy committee and say, here are all the recommendations, right?
Okay, so there are some
It's
additional.
still to be done, right?
Right, okay. And in addition to those August revisions, suggestions, and the staff suggestions that Cecilia is referencing, there is also an additional rollover contribution suggestion that you have. Did I understand that correctly?
Yeah, it's 2 pages that are specific to compliance with Code Section 401A31, and
Okay.
it was an attachment to the materials that you were provided.
Yeah, and that's the one I'm looking at now. So, with my board policy hat on, I can look forward to making some rules and regs changes based on the composite of these suggestions.
Correct.
Okay, and then we are, as far as you know, good to go. So if we decide to go one of the 2 routes for IRS review, we will be in. We will have done everything we think we have to do before we do that. Is that
Correct.
what you're saying? Okay.
Yes.
Thank you.
In fact, and that raises a good point. Not only will you be where you need to be now, we've actually recommended some amendments that would put you ahead. So there are some amendments that aren't required until 2024 or 2025. Those are built into the proposed changes that we provided.
Great. Thank you very much.
You're welcome.
Further questions?
All right, thank you. At this point, I'll introduce my partner, Audra Ferguson-Allen.
Thanks. As Rob mentioned, I'm Audra Ferguson-Allen. Rob and I work together and have worked together on these reports as well. So, can you hear me okay? Okay, I'm louder typically than Rob is. I'll cover the operational compliance piece. Again, I'm not going to walk through the whole report, but I'll highlight some things. For the operational compliance, as Rob mentioned, for the plan compliance, we took a look at it as if we were the IRS going in for a determination letter. For the operational compliance, it was a little bit different because we're no longer just looking at the terms of the plan document. So the information that we received to compile the operational report really came from our conversations with staff and the attorneys who had working knowledge on how they implement the plan terms. So in looking at operational compliance, we really took, in our experience, the common areas for operational failure, as Rob used that term because that's the term the IRS uses. So just operational non-compliance are areas that are common areas. Examples of that would be required minimum distributions, Code Section 401A17, which has to do with compensation that can be considered for contributions and benefits. So I'll talk through some of those areas, again, just high level, because I know you have all the details in your report. So with respect to Code Section 401A9, which is the required minimum distribution, which is that rule that says, it used to say at 70 and a half or April 1 following the year you turn 70 and a half, you have to start your benefit. It's now 72. So we talked through that issue. And really what we're looking at is the staff, the system monitoring members who are starting to reach that level to make sure that the benefit gets paid out to them or they attempt to contact them. And there are really good systems in place to make sure that the members who are entitled to annuities are notified. They go through a lot of searches to try to locate those individuals if they are not responsive. And so our recommendation on this piece was for those dormant accounts. And so those are those accounts that are entitled to only a refund. So they're not entitled to an annuity. We understand there aren't very many of those. And again, staff does a really good job of making sure they stay on top of that age, but that the same level of processes to try to locate those individuals for the annuities is also applied to those accounts as well. So we just talked through that as well. We also noted that the rules and regulations that we were just talking about make reference to if somebody's missing or can't be located, turning the refund over to state unclaimed property. And so that raises some concerns with the exclusive benefit rule. And so we cautioned against actually implementing that term of the rules and the regulations. What that has to do with the exclusive benefit rule means that you hold the assets of the trust for the exclusive benefit of the members and beneficiaries. So when you pay money out of a trust fund, even if it's to the state, you are moving money out of the trust fund and it's no longer being used for the exclusive benefit of the members and beneficiaries. So we always caution against doing that and instead putting in more processes to try to locate those individuals and even utilizing search processes that the state unclaimed property may use without actually turning the funds over to state unclaimed property. We also highlighted the fact there's a process in place where if a member is entitled to $200 or less and they separate from service, as a matter of course, that amount of money is distributed to the individual. That's not specifically set forth in the plan or in the rules and regulations. So that's something we recommended, either to conform the plan document or rules and regulations to that practice, or just eliminate the practice. Either way would be fine. And then we looked at the Code Section 401A17, which is the limit on the compensation. It's a federal limit. So for 2021, that limit's $290,000. So it's a pretty high limit. And in fact, new limits for 2022 just got released a couple hours ago. So it's a pretty high limit, and as we've been told, that there aren't very many members that hit that limit, but the system is monitoring it, staff is monitoring it. I think we were even told in the past 3 years nobody has hit that limit. So in good shape there. Again, Code Section 415, another area where we often see errors, and this is a limitation on the amount of benefit that can be paid out to a member, and then sometimes when we're talking about after-tax contributions or service purchases, it can also impact the amount that can be received by the system or paid by an individual member. And through conversations with the staff and having a good understanding of how the staff is working with the actuary, because this really pulls in actuarial compliance. Again, we did not see any cause for concern here, and it looked like the plan was operating as it should. With respect to rollovers, as Rob mentioned, we did make that one recommendation for the plan document. As far as operational compliance, as part of our review, we provided Ms. Carter with a copy of updated special tax notice. So what that is, it's a notice that goes out to any member or beneficiary who may be receiving a eligible rollover distribution. So for a plan like you, oftentimes that's a refund. And so we made sure that the staff has the most current version of that. That's a safe harbor that's been provided by the IRS. And again, the last, one other item with respect to the rollover, we did note that the handbook talks about automatic rollovers, and as we understand, that's not implemented, it's not part of the plan, it's not part of the rules and regulations, so we just recommended that that be cleaned up from the handbook so there's not any confusion about that. But again, that's not a federal law concern, we just wanted to not cause any confusion with the members. The last two items that we looked at looked in really good shape. It was the return to work. So whether or not the staff is monitoring separation from service before a member returns back to work. And again, operationally, that looked to be in really good shape. And our understanding is the staff really does monitor that. And then the last act is the HART Act. That's a federal act that has to do with service members who are also members of the plan. And again, that looked to be operating as it should under federal law. So with that, I will pause and answer any questions anybody may have.
All right. Are there any questions? Jane? Absolutely.
As always. When you say that we should hang on to this money and just look harder for people and access whatever systems the state is using and whatnot, I'm just curious, at some point, do we call it good? Or do we just hang on to it forever?
Yeah, so you hang on to it. So you hang on to it forever. So the way most governmental retirement systems do it is they create an internal forfeiture, so it's never truly forfeited. So the member or beneficiary always has the right to come back to the plan to claim that, but they create an internal forfeiture so that it goes back into the plan and kind of helps clean up the books, the accounting from an accounting standpoint, but it never leaves the actual plan.
Is there any interest earning responsibility if you hang on to this money?
Well, no, it's a defined benefit plan. So they're entitled to the benefit they're entitled to. So it's a little bit different than a 401k plan or a plan of that nature. So no, there's not that similar type of interest earning.
So it's just sitting there.
It sits in the plan, and the plan can invest it along with all the other assets.
Okay, great. Thank you.
Yeah, you're welcome.
I'm just kind of curious, and is that consistent with how NPERS handles it? Do you know? Or, never mind. That was a bad question. I'm sorry.
Yeah, I don't know. I can tell you in our experience with other retirement systems, we are only aware of, I think, 2 retirement systems in the country that do send it to unclaimed property. Everyone else that we work with has either abolished the practice or they've never done it anyhow. And again, it has to do with that exclusive benefit concern from a fiduciary standpoint.
Excellent. Thank you. Additional questions? Seeing none, so thank you very much. So all in all, it sounds like a pretty solid report.
Yes, so kudos to the staff.
I was just, thank you for saying that. I was going to say the same, so thank
Maybe
you.
one quick question. How do we end up with the dormant? You mentioned the dormant, and what do you call it, dormant?
Dormant accounts.
Account. How do we end up with the dormant account?
People forget. They forget, move,
So,
pass away and didn't tell family. And
well, but
Yeah.
you said it was a cash, but not somebody who would have eligibility for annuity.
Well,
Yeah.
we have both. We could have both. We could have non-vested, and they just do a refund, and they forget about it. Or, we send a letter that says you've left, you're entitled to these options with your money, and they put it down and forget the letter and forget about the money.
So these are decisions that are made right when somebody leaves,
Yes, and they don't act on it.
and they never
Act on it.
act on it. So
Yeah.
this is somebody that's like they forgot. Like this is right after they leave.
Is when we notify them. But if
Okay.
somebody doesn't act on it, years can go by, and then they move and they forget about it, and then on the other side is the one who is entitled to the benefit.
Yeah.
They left
I
10
get
years
that, yeah.
before and just totally forget, oh, I have to apply for this.
Yep, I get that part of it. It was just
Yeah.
the people with the cash balance. Yep.
W-
It seems weird.
I will, next month, I'll write a note, I will bring you the checks that haven't been cashed. We have sent the check out, and they didn't cash the check.
Okay, thank you.
Yeah, the dormant account issue is pretty common. Every retirement system has it. Oftentimes, it's somebody who worked for a short amount of time and left, and then often passed away, and their family members don't realize that this account is out there and possibly available to them.
Okay, thank you.
Mr. Chair.
I think I have a follow-up question, and I'm not sure if it's for you or for the chairman or Ms. Carter. In connection with this whole transition process, my recollection is that the Nebraska, the state required us to do an internal audit of audits kind of a thing, and that is what you have completed? Is that the special audit is what they have now done? So does this report that you've given to us, how and when does it go to the state, and does it not go to the state until after we've implemented your suggestions, or what's the process at this point? Whoever.
Yeah, that's a great question. So under the legislation, we have to provide a final report by November 15th. And so, and also 35 copies. And so we will take this report. We wanted to have this meeting first to see if there were any questions or any items that we needed to clean up. So we will take this item or these reports and make it look a little bit more official. The content will be the same, and then meet that November 15th deadline with the copies.
So that goes to the state, and they will have a list of the, I'm going to pretend, 7 things we're supposed to do to our rules and regs. I mean, the suggestions, the August suggestions, and the couple suggestions you just made will be in there as suggestions, and it will still be up to us to make those changes and then somehow establish that we did what you suggested.
Yep.
Is that
So-
what happens?
So what kind of how I see this going is Cecilia mentioned that her and her staff had some additional issues or things that they want to do, and we would incorporate that, and we would make some decisions at the December OSERS meeting, which is prior to when the Ice Miller folks will present to the retirement committee. And so we'll have a recommendation, and the board will decide if we want to get the determination letter and the other document, and then hopefully we'll have that all in a nice bow when we go in front of the retirement committee then. So, but I see the legal counsel coming forward.
Yeah.
So you did it. You did it now, Jane.
I just think it helpful to know on December 8th at 3 p.m. there'll be the hearing in front of the Nebraska Retirement Committee. You mentioned it, but I just thought it would be important for you to know that.
Yeah, and I think Ice Miller is planning to present either in person or virtually at that as well. So, again, I think what our intent is to have it all in a bow before it crosses over to the state as a.
And we will actually send are the 2 reports. We're not intending to send the draft rules
Right.
and regulations or what we sent in August at this point in time. And we will send it directly to Ms. Carter.
Right, because I believe, Ms. Erdenberger, I have to file it with the clerk of the legislature, retirement committee, something. And then I'll make sure everybody has full copies.
Okay, any additional questions? All right, thanks, Ice Miller. Thanks, Megan.
Mr. Chair, if I may, I just want to say it was an interesting exercise to go through, eye-opening, and learned some things. And as a result, there's a new tool we're going to ask for out of our actuary so that we can make it a lot easier on us with regards to the 415 limits, because now we are starting to see that we have more members who are retiring with enough years of service that we're pushing up against the limit. And so this tool will allow staff to make some decisions on whether they need to bring that one to me for further review. So this was a worthwhile exercise.
All right, thank you. Thanks again to the Ice Miller folks. Thanks, Megan, for the clarity on the hearing date. Okay, we'll move on to agenda item number 5. Cecilia, the Executive Director's Report.
Okay, Director Gerke and I met in October with others of our respective teams, and I think the big takeaway in the month of October is that NPERS is continuing to work on engaging a project manager for this OSERS transition. At the NPERS October meeting, the NPERS board did approve the engagement of Gartner Consulting to oversee and assist NPERS with the initial stages of the transition project. So basically assisting them with writing RFPs and negotiating vendor contracts, and then NPERS will decide next year if they want Gartner to work with them even further. I shared that Gartner presentation with the board earlier this month, and it appears that they've been engaged, so they'll start working in December. I do want to note for the board that beginning with the December 2020 meeting, I'm going to add a standing agenda item called OSERS Transition Report, so that it's not just part of the Executive Director's Report and we don't lose sight of it, and there's always something to talk about with regards to the transition. The OPS Board of Education is working on reviewing the experience study to decide on assumptions for the OSERS plan, so that's currently going on. The OPS board does have till approximately January to make a decision, because then we turn the data over to the actuary to start the valuation report. One other thing that came out in conversation, which we'll talk about a little bit later, since the responsibility of the OPS Board of Education is to approve retirement refunds, accounts payables, things of that nature, which this transition board would review and approve, I'm just going to keep giving you the report, but just give the totals in the meeting so that it stays in front of your eyes as well, and you have an understanding of who's retiring, how much is retiring, how much money is moving in and out of the system every month. So with that, for the month of November, the pension payroll was $11,641,000 to 5,251 payees. Staff payroll remains at $32,303 for the month. 7 new retirements for the month of November, with first pension payment December 3rd for an addition of $7,852 to the monthly payroll. There were 11 pensions terminated due to the death of the retiree, and 2 that were terminated or continued on to a joint and survivor annuitant, for a net total of $17,515 being removed from the pension payroll. We will be processing 17 refunds to former OPS employees for a total of $302,194, and the accounts payable for the month of November is $35,400. That's a little larger than normal because that includes the cost from the actuary for the experience study, which was within her contract, and it was the right amount. With that ends the executive director report.
All right, thank you, Cecilia. Are there questions for Cecilia regarding the executive director's report? All right, seeing none, thank you. Moving down to board committee report, Cecilia.
That was just open for if anybody, board members want to, like trustee report, anybody want to talk about anything.
You changed the language on me, so this is our traditional opportunity for anybody on the OSERS board to offer up anything. Okay. All right. With that, we'll go to agenda item number 7, potentially go into an executive session.
I move the OSERS Transition Board of Trustees go into closed session for the protection of the public interest and for the prevention of needless injury to the reputation of individuals, to discuss with Megan Niles-Brash, legal counsel, and Cecilia Carter, legal matters concerning the OSERS plan.
All right. We have a motion. Do we have a second?
Second.
We have a motion and a second. Is there any discussion? Seeing none, Cecilia, would you call the roll, please?
Logan.
Here.
Block.
Here.
Head.
Here.
Hersenbach.
Here.
Erdenberger.
Aye.
Johnson.
Aye.
And Bourne.
Yes.
7 ayes.
All right. We are in executive session.
At 4:39. No.
So let me. Okay. So we're back in back out of executive session. Cecilia, would you call the roll? Here.
Block.
Here.
Erdenberger. Here. Head.
Present.
Hersenbach.
Here.
Johnson.
Here.
Logan.
Here.
7 present.
Okay, we do have a majority. So with that, I would accept a motion to adjourn.
So moved.
Second.
We have a motion and a second. All in favor?
Aye.
All right. Thank you, everybody. Buddy.